Aloha. My name is Adriana Nunes, and I am presenting a review of the terms of use for Priceline.com. This is in connection to my digital marketing and law course at Full Sail University. Nothing I say or disclose within this video should be taken as legal advice, as I am not an attorney or lawyer. This is strictly for educational purposes. If you find yourself in need of legal advice, please reach out to a local lawyer or attorney in your area, or contact your local bar association for more information. For those who are unaware, Priceline is an online service provider of package or bundle travel services. These services can include flights, hotels, cruises, and/or car rental. For this presentation, I have looked over Part 1, Legal Action, within the Terms of Use Agreement on Priceline.com, located at the end, the second column on the bottom of the home page, titled Terms and Conditions, as of November 2021. During this presentation, I shall discuss whether or not these terms of use are a valid contract, if visitors are or should be bound to the agreement with or without the need to click agreement, if it would be possible to sue Priceline if a dispute arose, and what changes I recommend to Priceline for their terms of use. Let's begin. Is the terms and conditions a valid contract? According to the Legal Information Institute at Cornell University, a contract is an agreement between private parties creating mutual obligations enforceable by law. With this definition, the terms and conditions of Priceline are indeed a valid contract. The private parties are Priceline LLC and the user. The mutual obligations are the entering of information by the user and package presentation by Priceline. Can one be legally forced to use the site? No. But on their own free will, one is able to access and use the site, thus enters an agreement of use of the site. Are visitors bound by the agreement, even with or without clicking proof of agreement? This is a mixed answer, as there are two types of terms of agreement. The first is known as browser wrap agreement, and the other, click wrap agreement. This was by Legal Nature. Both of these are ways to present the terms of use on a website, but both have advantages and disadvantages. Since the link to the terms and conditions, or terms of use, are not plainly presented as they are located at the bottom of the home page, they are enforceable to an extent. They are partially binding, as courts have found the terms to be presented in a manner which do not fully create a binding or enforceable agreement. This is also because the current terms are presented as a browser wrap, meaning there is no requirement to prove agreement or acknowledgement. If they were presented in a click wrap manner, which requires some action on behalf of the user to agree or acknowledge that they have seen this agreement, this could be done with a browser app as well, if it was in places in a position that could not be deemed overlooked or hidden. This could be on the login page or by the search button. They are enforceable to the extent of reason. So the clause relating to copyright and trademark is enforceable, but enforceability of arbitration could be limited. It would be reasonable to expect a user or consumer to allow the company, Priceline, a chance to make good or whole in the event of a dispute. Can Priceline be sued if there is a dispute? Yes. Regardless of the terms of use in this case, it would be reasonable to take civil action against Priceline. The terms state it needs to be handled in either arbitration or civil court after 60 days if the issue is not resolved. And these are supposed to be based on the laws in Connecticut. And they limit jurisdiction to only Connecticut. This actually oversteps some of the legal standings of doing business in other states. So this tends to be overlooked many times. They also have clauses not allowing class action lawsuits. However, this is not possible. And they have faced their share of class action suits. Their terms of use are not fully enforceable, as there is no indication of seeing or being aware of the terms. Thus, there is no legal binding of agreement between the two private parties. It is reasonable to assume the use of the site has some binding, but not to the extent of some terms of use. What are some changes or recommendations? Change the terms of use to either include more visible location links, such as near the submit button, login area, and even join areas. This would mean the consumer will see them every time. Make them a normal size and color. No need to hide them. The other option here is to make them a click wrap, meaning make there be an acknowledgement or agreement clicked by the user. This could simply be done by having a pop-up with links to the terms, which has an I agree, I decline, I acknowledge, or I do not acknowledge. These are ways to prove the consumer was aware. They may reroute declines to a page which says something about sorry to see you go. If they do not acknowledge seeing the terms, it would be hard. So if they click they do not acknowledge, it would be hard to prove they did not see them, since they would have had to click the button. This could change the enforceability of the term. Mahalo nui loa for viewing this presentation on my review of Priceline's terms of use. This has been Avriana Nunes, student with Full Sail University.